All rise. Court of Appeals Division 1 is now in session.
Thank you. You may be seated. We're here today in Scottsdale 101 versus Maricopa County. Our case number is 1CA-TX140003, 14008, 14001, and 14012 as consolidated matters. These proceedings are being audio and video recorded. We'd ask you to identify yourself and your client when you come to the podium. Appellant will be responsible for reserving any time that you'd like for rebuttal. Otherwise, each side has 20 minutes. We have conferenced this matter this morning, and we hope we're familiar with the facts and the arguments that have been presented. We look forward to your argument.
Good morning, Your Honor. I'm Brian LaCourte. I'm joined by Bo Royston of Ballard Spar for the appellants Scottsdale 101 and Vestar. If I may proceed.
Please.
I'd like to reserve 5 minutes for rebuttal, and I'll make a mental note at 15 minutes to stop talking. Good morning. This tax controversy involves an erroneous classification and an error correction claim for two theater properties, the Scottsdale 101 Theater Complex in North Scottsdale, which contains the iconic Cine Capri, which I think I mentioned in a footnote was one of my first dates in high school as a student at Greenway High School in Phoenix. This case also involves the Desert Ridge AMC Theater Complex in the Desert Ridge market area of also North Phoenix. The tax years in question for both cases are 2004 to 2008. During that time, Maricopa County and the county assessor classified both theater complexes as Class 1 commercial. It is our contention that that's an erroneous classification, that the property should be classified in Class 9. The specific subject property that we're talking about is each of the theater complexes, not the larger developments that contain any number of commercial establishments. I'd like to make a brief introduction about classification in the property tax context and briefly discuss at least an exhibit showing the nature of the Scottsdale 101 complex and get right to the statutory construction issue at heart in this case. Classification involves determining the use of a property. Often parcels are used in multiple ways and have multiple uses and therefore have mixed use or different assessment ratios. Classification is important because it determines what percentage in a particular class will apply as the assessment ratio or assessment percentage. The normal structure of property taxation in Arizona is that use is determined, classification is made, valuation is conducted, then the full cash value is multiplied by the assessment ratio determined in the class. The legislature has set out several classes in Chapter 12. Class 9 is the one at issue here. Class 9 has a 1% assessment ratio, so in this calculation, the value would be times by the 1% assessment ratio, which gives us an assessed value, which then turns into a multiplication of the tax rate and then a tax bill. In this particular instance, the county contends that because the Scottsdale 101 larger development, and in the instance of the Desert Ridge development the same, that because there is an area that consists of a shopping center for valuation purposes, that everything in that shopping center must be considered retail use and cannot have a primary use the subject of a mixed assessment ratio. And I'll get into that in more detail in a moment, but what I'd like to do is hold up this exhibit that was taken from our summary judgment briefing and our statement of facts. This is at index record 16 through 19, It's Exhibit 3 to our separate statement of facts. This is an example of the larger Scottsdale 101 complex. This is the theater, which we denoted as A in our briefing below in the tax court and also in the record. This entire improvement, separate structure, is the Scottsdale 101 theater. The remainder are commercial establishments that are spread throughout the development. This is the subject of the Class 9 positions by the taxpayer in this case.
Is there any issue regarding parking spaces for the, is that categorized separately?
Yes, dedicated parking is typically considered separately, and that is not an issue in this case. The taxpayer is not claiming that parking spaces are included, whether they be common spaces or spaces adjacent to the theater complex. But that brings up a very interesting point, and it really sort of gets to the reasoning of the county. In this case, the county concedes, or at least assumes for argument, that all of the Class 9 factors are met. Those factors are that it is an improvement that is the subject of location on government land, a lease with the government, the improvements are owned by the lessee during the lease but revert back to the government at the end, and most importantly that the improvements are used for specific purposes, enumerated activities. We've litigated several of these, but in this particular case it's entertainment activities, which of course a theater is primarily used for entertainment activities. The question then becomes, if that theater constitutes Class 9 use for, primary use for entertainment activities, which the county admits or at least concedes, is there a competing primary use that cancels out the entertainment activities? That is effectively the county's position. The county is saying don't treat the theater complex as an improvement that is Class 9, but instead treat the entire shopping center as primarily used for retail sales that cancels out the primary use of the theater improvements.
I think the county is also suggesting that your clients receive some type of benefit by being valued as a shopping center. They're saying, if they get the benefit of that for valuation purposes, why shouldn't they be treated as a shopping center? Did your clients receive a benefit?
Well, there is some argument of whether that's a benefit or not. There is a statutory valuation method that was used in this case and for this entire development as a shopping center. But the important point, Judge Catani, is that criteria for shopping center valuation, not classification, but valuation, is what are the nature of the commercial establishments. There has to be at least 3 that are for retail use. If there are 3 for retail use, the valuation approach is statutory and it's as a shopping center. That valuation is not on appeal, whether that was a benefit or whether that was how this entire development should be approached is not the issue. The issue is, can you take a statute that calls for 3 commercial establishments to be retail and then assume for classification that the entire property is a shopping center Class 1? That's the wrong analysis.
Well, but counsel, if you look at them separately for terms of classification, wouldn't you look at them separately in terms of valuation?
That is the critical question, and our position is this. The county itself has used a cost approach of valuation for shopping centers and still implemented mixed assessment ratios. It is a very important part of the record. It's at Record 21. It's in our controverting statement of facts in paragraphs 29 and 31. If you look at those paragraphs and exhibits B1 and B2, they are examples, public record, of the county treating a shopping center under a cost approach for valuation, but yet providing Class 4 mixed use classification for a daycare facility. These are miles away from our client's property, and Class 1 commercial for the remainder, and the cost model is the same. If I may hold up one more chart just to demonstrate this. And I apologize, this is the nature of the record, so it's rather small. This is not a unit value concept where you take one entire going concern, treat it for income valuation purposes, and then decide the entirety of the unit without separation is valued at X. That's not what this valuation is. This is a cost approach valuation of improvements, and because it's on government land, improvements are actually considered personal property on the personal property roll. Each one of these improvements, each one of these establishments has a separate cost value. The only calculation here for valuation is to add up the total and say all of those separate improvements add up to X. The theater in this case is the Scottsdale 101 complex that has an improvement value separate to that theater. So if they separately value the theater as an improvement, and if Class 9 specifically says that improvements that meet certain criteria are to be given that assessment ratio, then that is the calculation. The valuation statute at issue here says, and I quote, that 3 commercial establishments must be, and I'm paraphrasing now, must be used for retail sales. Not all commercial establishments, not the entire area, just 3 commercial establishments. There has to be gross leasable space, there has to be an anchor tenant, there has to be an owner occupation, or at least a long-term 15-year lease. Once those criteria are met, the area is a shopping center for valuation, and there's a basic cost model plus depreciation. In this instance, the area qualified as a shopping center, but not all of the commercial establishments are retail. When there is a separate improvement that is a different use, like daycare, as the county treated that separately, it should be accorded this mixed use, mixed assessment ratio.
Are you aware of other instances where the county has applied a mixed-use assessment in a shopping center setting, such as the daycare example you gave?
Well, we gave 2 examples in the record where we showed the same cost approach and separate improvements. Actually, the cost numbers are in the exhibits B1 and B2. So we have 2 separate occurrences of treating a daycare as within a shopping center as a separate classified property and a lower percentage. We have several examples of mixed-use properties where there is a primary use. So, for example, we pointed out that there are agricultural properties that are given mixed uses. And we also pointed out the assessment procedures manual, and I hope the court gives a close examination of this manual. Back in the day when I represented the Department of Revenue, this was an important tool for assessors to use in guiding them on how to value and classify property. The assessment procedures manual is attached as Appendix 1 to our opening brief. And it says at page 3.2.3 that the first thing the assessor does when there are multiple uses at a property is to first, and I quote, first identify all of the property uses occurring on the parcel and the legal class appropriate for each use. Identify the uses for the land and improvements separately. Then the second step is next determine full cash value. So I'll stop there. The first step is identify use and classification. Where there are multiple uses, as here, there are mixed classes. Then determine the full cash value. Here the full cash value is the sum of the improvement values. That's all it is. And so our position is, even if you follow their own assessment procedures manual, which courts have determined is authoritative absent a conflict with a statute, if you follow that manual, you do exactly what the taxpayer is suggesting should have been done here, was erroneously done by lumping all of this into Class 1. One of the examples in the assessment procedures manual is mentioned on the very first page of the excerpt in Appendix 1, 3.2.2. It talks about a farm that has primary use as agricultural, and then other portions of the parcel that are used for different purposes, residential and a commercial, a fruit stand. And then later at 3.2.7 in the manual, it teaches how the assessor handles that. You appraise the house under the appraisal methods for a house, you appraise the citrus stand and the farm under the appraisal methods for those properties.
For those types of properties, you don't have a specific statute like we had here, the pre-2009 version of 12001 that just says real and personal property of shopping centers is included.
Well, we have a primary use statute, and in the agricultural properties, primary use for agriculture has to be present for that to receive agricultural classification. And of importance here, the county's sole position, and was the tax court's position, the valuation statute is not a primary use statute. So just like these examples that we're giving, the valuation statute does not require primary use. It's a misinterpretation. If the court reads the language, it's fairly clear. The primary use in the valuation statute is just that 3 commercial establishments must primarily be used for retail. The rest of the commercial establishments do not, nor does the area that constitutes a shopping center have to primarily be used for retail sales.
What's your take on why the statute was amended, or was it necessary? I'm talking about 42-12-001, the 2009 amendment, where it says real and personal property of shopping centers, then the addition is other than property that is included in Class 9. Under your theory, is that just surplusage? Was that already the law under the previous statute? Was this just because we're adding charter schools now, or what's your take on the additional language in that statute?
And that was a 2009 amendment. Of course, the period here is 2004 to 2008, but it is telling for this reason. Our take is the charter schools were being included in Class 9. Charter schools can be in shopping centers. That amendment was part of the entire charter school amendment. It was not separate from the charter school issue. So our view is that charter schools are Class 9, and it's only that portion in Class 9 that's used as a charter school. That's in the amendment. And likewise, part of that same bill before the legislature was that other than Class 9, meaning if a charter school is in a shopping center, it can be other than otherwise in Class 9, which is exactly the point we're making here. A shopping center can have mixed use. One final point on that, and I'll reserve my remaining time for rebuttal. The county at page 9 of their brief makes the following statement: commercial establishments are other than retail in a shopping center. They're not all retail. Many are not. They're banks, they're restaurants, they're tax service providers. So a shopping center by its nature can be mixed use. And like any other mixed use property, like the very examples of daycare and others that we've given, they should be treated accordingly with mixed use percentages. I have about 3 minutes and 20 seconds left. I'll hold that for rebuttal. Thank you, Your Honors.
May it please the court, counsel, my name is Roberta Livesay. I represent Maricopa County. I think the court has a pretty good understanding of what's going on with these statutes, particularly Judge Catani, your last questions. This is really not a matter of statutory interpretation. This is just a matter of statutory application. The statutes are pretty clear. Class 1, paragraph 1.8, says specifically that shopping centers, whether they're valued in accordance with 13101 or valued just as to full cash value, they're included in Class 1. All commercial establishments that are part of that shopping center are included in Class 1. Last time I checked, a bank was still a commercial establishment. It's not a retail establishment, but it is a commercial establishment. And if the statute had meant only to capture those retail components, it would have said so. But commercial is included in Class 1. If you have a daycare center inside a shopping center, that's not a commercial establishment. And the legislature has specifically provided for a classification for a daycare center.
Where are you coming up with the word commercial, though? And I'm just looking at the definition. It says real and personal property of shopping centers. You're using the term, as long as it's commercial, but is that
I'm quoting from my brief, where Mr. LaCourte looked at page 9, and he said that a bank is not a commercial establishment because we use the word commercial on page 9 of our brief.
But in terms of the statute, if you're just saying real and personal property of shopping centers.
It's in Class 1, Your Honor. Class 1 is for commercial properties. So what you have to look...
Where is that established?
Give me just a second. And I have to apologize to you at the moment. I don't have the full text of the statute with me, and I'd hate to take up my time looking for it. But that's the argument in any event. When we have a specific classification like we have for daycare centers or residential, obviously that property falls within those confines of that statutory subclass. But with a shopping center, the law is very specific. It says a shopping center is included in Class 1. Then we have also the issue of what is the primary purpose. The primary purpose has been declared by these taxpayers when they accepted the shopping center valuation that was provided by the assessor after they met all of the other definition portions of this shopping center statute. It has to be an area comprised of 3 or more retail establishments having a certain number of square feet and also having the same management, owned or operated, managed under the same management, having things like cross easements for parking, for instance. The parking situation for a movie theater, it's parking that is available for the entire shopping center. It's not reserved or set aside for that movie theater. Or at least there's no fact in this record from which we could answer that question any other way, except that this movie theater is an integral part of that shopping center. The fact that it might be separated by parking spaces and not be conjoined by common walls doesn't make it any less a part of that shopping center.
What if this were just 2 parcels, and there's no question that the movie theater complex is on the second parcel? Let's say they're even owned by 2 different people. The county doesn't have any disagreement that it would be Class 9. The assessment would be based on, it would not be Class 1. Is that accurate?
Your Honor must have read the transcript of the oral argument in the tax court, because I think Judge Fink asked me exactly the same question. It's really not a hypothetical that I can respond to without more detailed information, because part of the definition of a shopping center is that it is owned or managed as a whole. And you do have, it's very typical in shopping centers to have the anchor department store wholly owned by Macy's or wholly owned by Nordstrom. If you read the Nordstrom case from this court, you'll see that Nordstrom at Scottsdale Fashion Square had applied for shopping center valuation treatment, even though part of its agreement with the Westcor was that it be taxed separate from the rest of the shopping center. In that case, they were looking for the income approach to value that's included in the shopping center statutes. It's not just a cost approach. It's also an income approach. And this court said, no, you don't qualify for that valuation treatment because you are appealing your taxes completely separate from the shopping center. You want to be valued completely separate from the shopping center. We don't have that here. We have a taxpayer who wants to be valued with the rest of the shopping center, but classified on its own.
And what's the benefit of being valued as part of the shopping center?
It usually results in a much lower full cash value. You get different depreciation factors applied in your cost approach, and in your income approach, you get a highly beneficial capitalization rate that the first step in that income approach is what's called the straight line building residual methodology, and it results in a much lower income value than if you had used just a simple direct capitalization approach or a discounted cash flow approach.
So if we have 2 completely separate developers and just happens that one is developing a movie theater complex right next door to a shopping center, you're saying the valuation would not be available to that movie theater developer, but there's no question that it would be a Class 9.
Not exactly, Your Honor. The valuation methodology would be available to that movie theater as long as it was part of the shopping center in the way the definition approaches it, which is owned or operated as a unit, owned or managed. It could be the word managed. So as long as you have all these management agreements.
My hypothetical is there's no management agreement. This is just a movie theater right next to a shopping center.
If it's on its own parcel of land and it's next to a shopping center, but it's completely separately owned and completely separately managed, there's no cross easements for parking or any of those types of things, I would say that movie theater would not qualify for shopping center valuation.
Leslie, can I ask you about the assessment procedures manual and the argument council has made as to its applicability in this setting? And I'm interested in your reaction to that and why you don't think it could be applied for this exact setting.
Well, first of all, Your Honor, the case law that we cited says you look at these types of administrative procedures when they're interpreting the statute that you're trying to apply. And in this particular case, we pointed out in our brief that the Assessment Procedures Manual does not apply Class 9 within the context of the mixed assessment ratio procedures that are outlined there. But the Assessment Procedures Manual can't give you any interpretation of a statute that's contrary to the plain language of the statute. And here we have paragraph 1.8 of 12001 that tells us that shopping centers are classified as Class 1. The same thing with the administrative code provisions, which was not discussed but is attached or referenced in their opening brief. These administrative procedures are written in the context of if the assessor determines that a mixed ratio should apply, then this is what happens. Same thing with the assessment procedures. It says first identify the property uses and then I determine what classes should be applied. So these are directions to the assessor that once the assessor makes that decision that there's a mixed assessment ratio, then you follow these processes.
Are you suggesting that the assessor has never applied a mixed ratio or assessment in a shopping center context?
No, Your Honor. I'm suggesting that the assessor has never applied a mixed assessment ratio in a Class 9 context.
Why, just enlighten me, why would the fact that it's Class 9 is on government-owned property, why would that make a difference?
Two reasons, Your Honor. First of all, the language in 1.8 that was applicable during this time frame, and the fact that the two statutes each have primary use requirements. Under this court's decision in Scottsdale Princess interpreting the Pasquera case, a property can only have one primary use. That's also Tucson Botanical Gardens holding, where you have the gift shop in the middle of the botanical garden, and the assessor there took the position that the gift shop could not qualify for the exemption. And this court, I think it was this court, it wasn't Division 2. So that's an incidental use. That incidental use doesn't interfere with the primary purpose, and you have to classify based on its primary purpose. Here they've already declared the primary purpose. They got the benefit of the valuation methodology. The statute 12001 requires that property be placed in Class 1. There's not a whole lot of room for interpretation. And if I can segue from that question, I think it was it might have been your question, Judge Winthrop, about the amendments to the statute.
Judge Catani,
I'm sorry, I apologize.
It's a good segue.
Okay. If you read the legislative history that we've provided, the House committee report and the fact sheets, you can see the whole purpose of that whole House Bill 2346 was to facilitate Class 9 for charter schools. And of course, you would add that language to 1.8 for Class 1 because you find a lot of charter schools in shopping centers.
Under the new statute, is this still an issue? Would a movie theater be treated, the statute just says, other than property that is included in Class 9. And if a movie theater is included in Class 9, under the new statute, is this still an issue?
Well, then we have to look to even a newer statute, Your Honor, because in 2012 there was an amendment to Class 9 that now says that the use has to be exclusive for one of those categories. And so I can't tell you categorically that a movie theater would now qualify, because movie theaters, as we've put in our briefs, are often used for other purposes, such as church services and business meetings and things of that nature. So there might have been a time period between the active...
Let's just hypothesizing a movie theater that does not operate as anything other than a movie theater. Would the mixed use assessment apply under the statute that says other than property that is included in Class 9?
My position would be that the movie theater still would not qualify, because the legislative intent in amending that statute was to allow charter schools to be given the Class 9 status.
Go to legislative intent, though, with language that simply says other than property that is included in Class 9.
Class 9 itself then has the paragraph that includes charter schools for mixed assessment ratio purposes. And we argued, even before the statute was amended, I take that back. Of course, we argued after the statute was amended, that putting that paragraph into Class 9, specifically providing for mixed assessment ratios for charter schools, strengthened the position that nothing else was entitled to a mixed assessment ratio with Class 9 as a part of it. Under the provision of you include one thing, you exclude everything else, the legislature had it intended to make Class 9 available on a mixed assessment ratio basis to all properties, would have approached the problem a lot more differently. They would have perhaps included a separate classification for charter schools located on government property, and have included language in Class 9 that made it less exclusive in the sense that it could be used for mixed assessment ratios. But again, in the cases that the court has dealt with, the CNL case and the Princess case, particularly the Princess case, the courts have made clear that both the land and the improvements have to have a primary use that is consistent with the Class 9 provisions. And obviously, a shopping center does not have a primary use that's consistent with Class 9. Its purpose is retail. Even if it includes an entertainment component, even if it includes an education component, it still has that primary use that is retail, which is not one of the enumerated primary uses. The legislature solved that problem with regard to an educational purpose for charter schools. It said, okay, we'll allow a 1% assessment ratio for an educational use. But they didn't do it for entertainment, which is what the movie theaters are claiming. They fall under that entertainment provision. There's no indication in Class 9 that the legislature wants to carve out an exception for entertainment, as they did for charter schools. If I can just have a moment to look at my notes, but I think we've covered everything.
Counsel, so your argument basically boils down to that whatever valuation you're stuck as far as the assessment ratio? Always?
It's more than that, Your Honor. It's because you are a shopping center, you are classified in Class 1 by virtue of paragraph 8 of Class 1. The fact that they are a shopping center is bolstered by the fact that they are also valued as a shopping center, where they have satisfied the primary use portion of the shopping center statute definition. And having satisfied that primary use, they cannot come in now after the fact and say, oh no, we're different, we have a different primary use, at least our little portion of it. And I think another thing that's important to bear in mind in these kinds of situations is we're talking about giving a tax benefit to a discrete taxpayer here on a very technical argument where they have to bring in examples from the agricultural and the residential arena to try and find support for their argument. But bottom line, it's a tax benefit that they're going after. That shifts the burden of taxation to everybody else. In property tax, it's a pie. That money's going to be raised no matter who pays it. Property tax system doesn't really care. Neither does the assessor. The assessor's job is simply to apply the statutes as it finds them. But when we start carving up statutes and interpreting them in a way that we pick a little piece out of here and pick a little piece out of there and pick a little piece out of there, makes the assessor's job that much more difficult. And the one thing the CNL Supreme Court was very clear about is that the tax statutes are supposed to be interpreted in a way that's clear and makes it easier for the assessor to apply them and not harder. And so I would ask the court to look at this in a very cold and analytical way and make this easier to apply and fairer to apply by sticking with the words of the legislature, which in this case, and I will admit it's a rare case, those statutes are actually pretty clear. Mostly I'm up here arguing vagaries of property tax statutes. In this case, I get to argue, and I would urge you to find that the statutes are actually very clear, unless the court has any further questions. Thank you.
The discussion about a tax benefit is improper. This is a statutory construction. What's more on point is Class 9 has specific identified legislative purposes that our own Supreme Court identified in the CNL Marriott case, and it is to encourage development on public land. That is the purpose of this tax statute in Class 9. The Supreme Court also said not to make the life of the assessor easier, but to interpret tax statutes in a reasonable fashion for the most logical and reasonable outcome to further the legislative intent, which is here economic development, not to parse out taxpayers based on some particular benefit. That is not what CNL said, and that is not what's happening here. The amendment to the shopping center classification portion is very broad. It does not specifically reference charter schools. It was part of the charter school amendment, but it includes, it exempts other property not in Class 9. So clearly there's an interplay between those two classifications. With regard to the assessment procedures manual, it does not identify any single class. It identifies mixed use for all classes. So the fact that it doesn't recite the words Class 9 doesn't mean that Class 9 is an exception to that analysis. It's included in that analysis. The truth is Maricopa County has effectively, as we briefed, left this class vacant as to these kind of properties with specific purposes. There's one, the Marquee Theater in Tempe, which got a Class 9 status from litigation settlement. The county has taken the approach that this is an impossible standard to satisfy. It is not. The example you gave, Judge Catania, about splitting parcels would be a natural byproduct of this. But parcels are not the guiding factor. Improvements are. So in this instance, the parcel is Scottsdale 101. The improvement is the theater. It's separate and it's classified under Class 9, which covers improvements, not parcels. Just like a daycare center within a shopping center is classified by the county in Class 4, not Class 1 commercial. By the way, Class 1 commercial is a catch-all class. It's a variety of different types of commercial properties or other types of properties. It is not related just to retail sales or by any means shopping centers. Valuation does not determine classification. Valuation, there are standard appraisal techniques like the cost approach here used. Lots of properties among or spread out different classes receive the same valuation approach, cost. Just like daycare was valued at cost and the rest of the shopping center was valued at cost, as shown in our exhibits B1 and B2 in that portion that I cited, also cited in our brief. Your Honors, this class should be administered by the county, if only by judicial intervention. The theater complex is an entertainment facility with entertainment activities that qualifies for Class 9 treatment as a separate improvement. Thank you.
Thank you both for your arguments today. We'll take this matter under advisement and issue a decision in due course. Thank you.